right, welcome back. This is Patents 1, Part 1, and we are in the textbook at pages 633 to 642. So this is our last section, right, from the textbook. So it's our last doctrinal section before we start looking at stuff that is more fun but unrelated to the more doctrinal areas of intellectual property law. Right, so we saw copyright, we saw trademarks, both registered and non-registered, we saw industrial designs, and now we're seeing patents, right? It's our last type of intellectual property that we're going to look at. And, right, like in our previous sections, we have a specific law that sets out the rules that apply to that type of intellectual property, and that is the Patents Act, right? And that is enacted by the federal government, as is the case for most other types of intellectual property law, because the federal government is specifically allowed under Section 91 of the Constitution, right, which says these are the things that the federal government can do to enact laws on patents, and as we saw, other types of intellectual property law. So, what's a patent, right? A patent is an abbreviation for letters patent, right? Which, from my wild speculation, is something to do with the royal prerogative to give you a right, right? So the right given to you by the King or Queen of England to do something in the marketplace. But don't quote me on this. This is my wild speculation. What is that? Right? So like in other areas of the law, we have a monopoly. So the government is going to do something that is not true naturally, and it's going to say you're the only person who can sell this thing for this period of time, right? We saw that under all other types of intellectual property, right? We said that copyright is life of the author plus several decades. We said industrial designs is shorter, right? And we said registered trademarks, for instance, can be potentially indefinite, right? So you can have a monopoly on that forever, potentially, right? It's also true of patents, right? The government says you're the only person that can sell that for a limited period of time, which happens to be 20 years, right? You saw some references to 12. It is now 20 years, right? And 20 years from what? That's pretty important, right? From filing. So from the date that you filed your application for a patent with the federal government. That's important, right? It's not the date that it's granted, it's the date that it's filed. So potentially, right, you might be unable to sell it for whatever period of time happens, between these two dates. And it can be quite a while because there's, as we'll see, there's a pretty lengthy procedure that the government engages in, again, as is the case for most registered types of intellectual property law, to look into whether what you're saying is true, to look into what you put on your application, right, which is going to say, I am me, and this thing does that, and the government's going to look into whether the thing does what you're saying it does, right, or can do what you're saying it does, and that takes a while, and therefore it might be a while before you get your patent and your commercial monopoly, but the period under the Act starts running from the date that you filed. So, what are the requirements for there to be a patent, right? So, first there's what we'll call the subject matter requirement. And we'll see that's pretty important. It has to be one of the things that the government says it can be. Typically, as we'll see, patents are concerned with inventions, right? So either, a thing that does something new, right? Or a way to make a thing that does something new, a process, or, some new application for an old thing. But either way, something that is, right, new, that you're inventing, right, has to be the subject matter, right, the invention has to be one that the government says is patentable. And we'll see there's basically 6 types. We'll look at 5 mainly. So it has to be patentable subject matter, and it has to meet the three main conditions. So all of this is very complex, right? We're getting a very bird's eye view, which is very sufficient for our purposes. So three main characteristics, right? It has to be novel. So again, as I said, new, right? So it has to be a new thing, right? One of the things that the government says counts. It has to be useful. We'll see that's important, right? So it's not just any invention that you made up. It's an invention that has the potential to do something useful. And as we'll see, generally that means something positive, right? So if you invent a machine that does something useful in killing people, typically that wouldn't count, because even though it is useful, it's not useful in the sense of it, helping society and contributing. And therefore, it's not going to count as useful. So it has to do something useful, has to do something commercial, right? It has to do something that is going to change people's or companies' lives in such a way that they're actually going to buy your thing. And it has to be non-obvious. And again, right, just from these keywords, it's pretty clear that these things can be redundant, right? What does it mean for it to be non-obvious, right? It means that someone who is, we'll see there's a standard for that, which is called a person reasonably skilled in the arts, which intellectual property lawyers like to call the posita. So the person reasonably skilled in the arts, right? So an expert, a normal expert, to put it that way, has to not think that what you're disclosing, what your invention is obvious. In other words, they're not able to have come up with it on their own in their living room. Not with the plan. Without the plan, right? They're not able to come up with it in their living room, because if they are, it is obvious. And again, right, it kind of gets us back to new. If it's obvious, right, it's not new. And so, as we said, when you disclose that, you are going to have a monopoly on basically everything. So making your thing, selling your thing, and for all intents and purposes, even though it's not mentioned, using your thing. Because, right, if people can't make it and you don't sell it to them, well then as a result they can't use it unless you've consented, unless you've sold it to them, right? And so you have a monopoly on everything. And you have a monopoly that is quite broad, quite similar to what we saw under trademark law. So under copyright, right, the first thing we were concerned about was whether someone was copying. And generally that meant actual copying. It meant someone, taking a chapter of your book and copying it. It's literal copying. Then we said under trademark, right, that we have a broader ambit of protection. We said that, we're protecting not just someone copying your exact logo, but also someone copying your logo to a certain extent that is misleading. So someone copying your logo but changing the color. Someone taking your brand name and changing a letter. All of these things, right, are hard to define, right? You cannot come up when you're writing down a law on intellectual property with the 20,000 ways that someone can change something just enough for it to be confusing, but not enough for it to be different, and therefore not confusing. And so we have this standard of confusing, right? We have the standard under trademarks that if someone copies your thing enough for it to be confusing, you're protected. It's broader than just the literal type of copying that we saw under copyright. Under patents, right, we have something similar because, as I just said, right, people are not just prevented from, making your thing exactly as it is. They're also prevented from making something substantially similar that does the same thing. And that's interesting, right? So in copyright, we said you can't protect an idea. You can't protect a purpose. Here, really, you can. Or at least you can to some extent. So the government's going to look at two things, as we'll see. The government's going to look at what it is, right? What your invention is, right? The plans, how it's made, what it is, how it works. And then the government is going to look at what we call the promise of the patent or the claim. The government's going to look at what you say it does. And that, to a certain extent, is going to be protected, right? To give you an example, if I have a patent on a snowmobile, it's not just someone copying my plan and making their own that is illegal. It's also someone making something similar, which is a snowmobile, that's my invention, that is used to travel over snow as a vehicle. That's my claim. That's protected. So someone for the 20 years is going to be prevented essentially from coming up with any similar vehicle for going over snow. Obviously, the standard is not specifically defined, right? Like a snowshoe most likely would not count. It's not a vehicle, right? And then we'll see there are obvious restrictions on how broad your claim can be, right? You can't come in and say, you know, it's anything that goes over snow. The government's going to say that's too broad, or your competitor, when they sue you, is going to say that's too broad. But that's important, right? What we're protecting under the monopoly is not just the invention itself, but the invention itself as it serves to meet a purpose, the claim, right? The thing that you say the invention does. And so, right, why would we want to have, a patent regime, right? Well, of course, there's a good reason, because when the government screws up, right, everything we believe in a competition-oriented society, in a capitalistic society where we want, companies to compete so prices go down and consumers are happy. It's a broad concept that we're trying to usually favor, right, in developed countries. And then the government screws it all up and says you have a monopoly. The government says, right, I'm picking this guy, and this guy's the only one that can sell it. It's the opposite of competition, right? And you're told in the book, right, that monopolies are typically associated with higher prices. That's a nice way to put it, right? Monopolies are higher prices. By definition, if you have a monopoly, your only constraint is how much money your customer is going to pay. It's not whether the competitor is going to come in and underprice you, right? It's not whether you're going to get poor coverage because everyone says you're selling it for more money than your competitor. All that doesn't matter because there is no competitor. And so it's not just a matter of higher prices, as the book says. A monopoly, by virtue of it, is you can charge whatever you want. And your only limit is, right, when it gets too high and people don't buy it from you. That's your only limit. And so the government comes in, gives you a monopoly. Opposite of competition, as I said. The government says, I'm picking this guy. This guy's the only one that can sell the thing. Has to be good reason. We saw a bunch of good reasons already. So under copyright, we said, right, the government wants you to come up with stuff, right? The government wants you to come up with a story. And we said, A, it's unfair if people steal it because it's yours. It's your property. It's like your house. And B, we said that people don't come up with stuff unless they're incentivized to do it. And so, if the government doesn't give you a monopoly on your story, you won't write it in the first place because you won't make enough money for you to justify sitting down and writing it. So that's the policy concern, right? That's a countervailing concern. It's a policy reason. That's the public interest in, favoring, research, artistic production that the government says is so important that they give you a monopoly. Then we said under trademarks that it's bizarre because the government is protecting very large companies who have, logos. And then we said, well, there's no way the government would give you a monopoly without a reason that sounds public. I told you it might be wrong, right? You might disagree with me. But the government says, right, that, that essentially to protect logos is to protect the public because it's unfair for people to be confused. It is unfair for you as an unassuming, honest consumer to go to the grocery store, try to buy a chocolate bar, and then, right, buy it quickly because you recognize the logo, and then be stuck with the wrong one because some evil market actor copied it. And the government says, it's so unfair that we'll give the people who came up with the logo a monopoly on the logo. So what's the policy concern under patent law? Well, it's much easier to see, right? The policy concern is we want people to invent things. And there's a very utilitarian aspect to this, right? It's not like copyright where we want people to write books, right? Books are important. But this is, we want people to invent things because that's how society moves forward, right? With computers, with, automobiles, drugs, everything, right? Everything in society that makes their lives easier, right? That sustains their standard of living in a developed country is there because someone came up with it when it didn't exist before. So obviously we want people to do that, right? It's good for society. And it's good for society in a way that might be the clearest from the various areas of intellectual property law that we've seen, right? Because you're not coming up with a book or a nice logo, right? You're coming up with something that is new and useful. An invention that changes people's lives, or at least it has the potential to do that. And so the government wants to favor that. That's a policy consideration that underlies this area of intellectual property law. Why do we give you a monopoly, right? Well, first, it's an incentive, right? Obviously, you're more likely to sit down and try to come up with stuff if you know that for 20 years you're going to be able to charge whatever you want and make a lot of money, right? That's why people come up with drugs. Second, right, the government says, that's important, right? We want people to disclose. So I'll write it down as invent, right? So as I said, we want people to invent things in the first place. And one of the reasons people do things in life is to make money. And therefore, if they can make money for 20 years, they'll invent things. Second, right, we want people to disclose. And I've said this before in previous weeks, before we looked at patents, right? We want inventors to invent things. So I invent a snowmobile, right, tomorrow morning. I'm the first on the market. That can be a tremendous advantage because as I come in, there's no one on the market. But obviously what's going to happen the next day, some big company is going to buy my product, take it apart, copy it, and then they can make $1 million of it tomorrow because they have this big factory and all these employees and these advertising channels, etc., right? And so I have an advantage by virtue of being the first on the market, but that advantage doesn't last, and typically, right, I'm going to be crushed by larger incumbent players on the market. So what might I do? I might keep it to myself. I might say, it's not worth it. I'll keep my snowmobile to myself until I'm 50 years old, and I have $1 million that I can invest into this venture. And that is bad. It's bad because people won't have snowmobiles until I'm 50 years old. And as a result of that, right, that 20-year period before someone else can invent a new one or a better one or a competing one doesn't start running. And as a result of that, right, we'll see sometimes you can improve something and have a patent on that partially. As a result of that, someone can invent, a 20 times better snowmobile because they don't know there's a snowmobile in the first place. And these are all very bad because they delay the normal pace of innovation and the access of the regular person to something that can change their life and change society. And so that's why the government wants you to disclose your inventions. Another thing that we saw, right, is registration. So we said under copyright that registration is not necessary. We said that you have a copyright by virtue of meeting the statutory condition. So you have a copyright because the law says if you meet 1, 2, and 3, you have a copyright. And 1, 2, and 3 doesn't include registration. And so you have a copyright by virtue of having a thing that meets the statutory conditions. When do you have a copyright? From the time that you meet the statutory conditions. On top of that, as we said, if the government says you can voluntarily register your copyright, which is the case, and we said there's a myriad of reasons why you might want to do that. The main one is, right, it's written down somewhere and you don't have to prove it every time in court, which is long and expensive. So by virtue of that, when the government says you can register it, that doesn't change anything because you have your copyright by virtue of meeting the statutory conditions. So even if you go out and register it, might help you for the reasons I just said, but it doesn't change the fact that you had your copyright from the beginning, from when you met the statutory conditions. That's a regime where either there's no registration or registration is not mandatory. Then we said industrial designs. You have to register them. What does that mean, right? Well, it means that you don't have a protected industrial design until you register. And so even if you meet the other conditions, it doesn't count as an industrial design because one of the conditions is registration. And there are cumulative conditions that you have to meet. And therefore, right, before you register it, it doesn't count. Someone can steal it from you. Then we looked at trademark. We said they can be registered and unregistered. Right? And we said that the regimes are very different, right? Depending on whether or not it's registered. And we said that either way the Trademarks Act applies. So what do we have here? We have mandatory registration for patents. Why is that? Well, because it's complicated. It's complicated like trademarks, right? The government wants to look at it because, it's complicated, right? We don't want people to just say, I have an invention and go to court and then sue a bunch of people, trying to claim that they've invented something, and it takes forever because there's a lot of conditions, they're complex, right? Complex meaning you'll have to hire an expert, which is someone that gets paid, $1 million a year in the billing rate to tell you what it is that is new, right? Or what the state of the art is in snowmobiles or drugs or whatever it is, right? That's expensive, inefficient. And if, you're going to have a monopoly, it kind of makes sense for the government to look at it first. Like I said, the government to look at whether the thing you says does something actually is what you say it is and does what you say it does, or at least has the potential to do what you say it does. The distinction becomes relevant as we move forward. And so you have mandatory registration, which means you don't have a patent until you've registered it, subject to what I said about retroactivity, right? So the 20 years starts from the filing, so in some situations it might go back, right? But it's not confirmed as a patent until the government's confirmed it. Government has to look at the things, right? Registration is not automatic, right? The government doesn't just rubber stamp it. The government looks at it, evaluates it, then grants it. And once the government grants it, registration being a condition of existence of the patent, then you have your sweet commercial monopoly for 20 years. And what happens, right? You might think that this is pretty serious stuff, right? The kind of stuff which, with all due respect, you don't want some, unassuming, untrained government employee in a government office somewhere making a decision about, because these are kind of serious, hardcore science conditions. And so what happens, you ask, right? Well, there's a bunch of very skilled individuals, some positas, right? Some persons ordinarily skilled in the arts, of various arts, that can look at it and see whether you meet the conditions in the patent office, what we call the patent the patent examiner. So someone has to get a license to be a patent examiner. In the government, they look at your thing, and then what do, right? They decide whether or not you have a patent. And again, this is serious stuff, right? If you've just invented a drug for cholesterol, you've just made $100 billion. And so there's a bunch of procedural safeguards to make sure that that very well-meaning examiner doesn't get it wrong. First, you have a right of appeal to the Patent Appeal Board, which is a bunch of even smarter people who sit on a board and make decisions. And then you have a right, by virtue of the Federal Courts Act and the Patents Act, to go to the federal court. That's your right. So if the board says no, the examiner says no, right? And the board says no, and then you're still convinced you're right, then you can go to the federal court. And the federal court, obviously, these things are somewhat complex, right? You don't get to redo the thing every time, but you have judicial review of the federal courts. The federal court has to look at it and see whether, it was done right. It looks like it was done right. And that's your right. And as I said, it's exclusive jurisdiction. The only place you can go is the federal court, which, as we said earlier, is a statutory court of limited jurisdiction. We have this court in Canada called the Superior Court, which is a court of general jurisdiction. The Constitution says if you don't have anywhere to go to the Superior Court. And the government says, well, where's the specific place you can go? The government says, if it's intellectual property, go to the federal court. So the federal court can only do the things that the government says it can do, unlike the Superior Court. And one of these things is intellectual property law. And in the case of patents, as I said, it's exclusive. Then you have all this nice stuff about international law, which I'm sure you found very interesting, but is not particularly important for our purposes. And you have a case to look at the concepts that we just discussed. It's the Tiva Canada versus Pfizer case. Again, these are very big, multi-billion-dollar drug companies fighting. That's typically the kind of people who fight over this. There's a lot of dollars involved, right? And they look at this policy issue, right? And so, right, we'll call it a bargain. That's because the court, right, some very smart judge 50 years ago thought that was a very compelling word, right? But that's really the same thing as copyright. Copyright's a bargain in terms of being a balance, right? An act of balancing competing interests. Generally private interests, you making money, making money from your invention, versus the public interest to access stuff and see your invention, right? It's a balance. The government calls it the bargain, right? The bargain is, right, as I said, you tell me what it is that you've invented, me being the government, and in return, I give you this sweet commercial monopoly that we keep referring to. And so the Tiva case discusses that, right? And it says that one of the important things is sufficiency of disclosure. Because, as we said, it's all about disclosure. The bargain is, right, we give you a monopoly because we want you to invent things in the first place, and because we want to know what it is. And we want to know now, not 20 years from now, right? Not just the government guy looking at it before they give you a patent. Everyone want to know now, so that in 20 years, anyone can make it. So you have to disclose your thing now to everyone. And as we said, quite interestingly, before you get your patent. Because it's 20 years from the filing, so when you file it, you don't have your patent, but you've already disclosed what it is. There's some ways to protect it in that interim period, but it's not particularly important for our purposes. What's important is, right, one of the important aspects of the policy considerations, of the bargain, is disclosure. You have to disclose it fully, and you have to disclose it now. So the court, basically the main concept in the case is sufficiency of disclosure. They come up with that, they come back to that policy debate, and they say, well, it all depends on the sufficiency of disclosure. So if you've not disclosed your thing properly or enough, right, you haven't met the conditions. So they're going to say, well, this whole thing is junk. And so even though you have a patent, right, if the court later on says you didn't sufficiently disclose, or the court can say other things like you've never met the conditions, someone got it wrong along the way, and the whole time you've had this monopoly that was wrong, and the court can take it away, right? Typically the monopoly is for 20 years, but if someone proves that you should never have had it in the first place, there's nothing that prevents a court from taking it away. That's a mistake that we often make, right? Monopoly sounds very strong, but it doesn't mean that it can't be taken away, right? Not because, right, someone wants to change the law, but because someone says you've never had a right to it in the first place, right? They say, got it wrong. And so, right, has to be sufficiently disclosed. If it's not, later on, the court, typically upon being asked by one of your competitors who wants to make the same thing, can cancel your patent and say it was never valid. So, you're also given the standard at paragraph 33, which I said, the posita, the person reasonably skilled in the arts, and they call it, right, a reasonably well-informed artisan dealing with the subject matter with which he is familiar to make the thing. In other words, your disclosure has to be sufficient. There's two aspects to it, as we said. What your thing is, what it does. They both have to be sufficient. It has to be sufficiently clear what your thing does. My drug cures cancer. That's my claim. It's not my drug cures a disease. It's not sufficient. And what it is. My drug is this molecule that I've made up, which is 6 carbons and whatever, right? That's the disclosure of the thing and the disclosure of what it does. If you've invented a snowmobile, you're going to have plans as to how to make it. And how do we evaluate that? Well, as I just said, you have to look at the posita. You have to look at whether someone, not just any idiot down the street, someone who's reasonably skilled in the arts, an expert, but more of a generic expert, can make the thing from what you've disclosed. That's going to determine whether you've sufficiently disclosed under the Patent Act. And the court goes back at paragraph 32, essentially what I said, but the court says, right, this is not just, we want to reward people for having invented something, right? It's not just about, right, like, we think inventing things is so nice that we want you to make a lot of money. It's not what the Patent Act is, the court says in paragraph 32, right? The court says this is more about forcing disclosure. This is about coaxing things into the public domain, as they say. It's about, forcing inventions. And so the monopoly is not the thing that we give because we think it's nice. It's what we're obligated to give to get the favorable social outcome, which we think is so important that it justifies the monopoly. Or to be more precise, right, for which the monopoly is our only option. People won't disclose it unless we give them a monopoly, so we don't have a choice. That's essentially what the court says at paragraph 32. And of course, right, you're also told in the questions under the case about the strategic concern. Why would people not want to disclose things? Well, obviously, right, because if you get your patent, right, you shouldn't get it in the first place if it's not sufficiently disclosed. But it's a lot easier for you, right? If it's cryptic enough and your competitors cannot make it, it's easier that way than your competitors making it and then you having to sue them and say, I have a monopoly, you shouldn't be doing that. It's more expensive to sue people than to have people not do it in the first place. So that might be why companies are incentivized in the first place to disclose as little as possible. But as we said, that's a very slippery slope because it can invalidate your whole patent and then you lose the whole golden goose. As I said earlier, right, there's a mention in section 43 of the Act that you're given as an example to the effect, again, as I said, that registration is not rubber stamping, that the government does not just, say, oh, well, it does look like a snowmobile. Right? The government actually looks at, whether you meet the conditions and whether your thing does what it says it does. Right? It's as much as you have to learn. It's a lot more complicated than that. In fact, the government looks at the promise. The government looks at whether, what you claim your thing does is not too broad and makes sense based on what you're saying. The government does not require proof that the snowmobile that they can make from the plans actually does work over snow. That might be a problem later on, but not for the government at that initial stage. And the standard, again, I'll write it down because it's not actually written in the textbook, but it's the posita, right? It's the person skilled in the art, is what they call it. So po is person, right? Skilled in the arts, posita. And you're told that filing patent applications, right, is a restricted act. Because as we said, it's pretty complicated, right? You have to, put the plan for your snowmobile, and you have to, say it goes over snow. But you have to say that in a very careful way. Because if it's too narrow, you're not protected. Because as we said, right, disclosure bounds protection. So if you say, it goes over a certain type of snow, then you're protected for that. But someone can come up with their own snowmobile, obviously not copying the exact same plans or substantially similar. It goes over a different type of snow, and not only can they sell that because you don't have a monopoly over that, they can get their own patent if they've invented something. And so, generally, you'll need someone very smart because your disclosure of the thing has to be detailed enough for someone to make it. A posita to make it, as we said. Then what you're claiming it does has to be carefully constructed. That's what they call claim construction, when the court interprets what you said, right? Well, your claim has to be properly constructed when it's written down, such that if you're not too narrow or too broad, because if you're too narrow, well, that limits your protection. Someone else can do whatever is outside of that. And if you're too broad, right, the court's going to say it's too broad, it was never valid in the first place. Right? If you're trying to claim a monopoly over all, vehicles going over snow, that's too broad. And so, for that reason, right, we have what they call patent agents, which are typically people who have, doctoral degrees in the arts. They're positas, and they're the people who write your patent application. They're the people who, write down your plan and your claim construction. And then you have this example of the mousetrap, right, which is somewhat interesting. Obviously, again, what do you have to take away from that? Well, first, it doesn't look that way anymore because people get paid a lot of money to do patent applications. It's not 3 pages anymore. And B, of course, right, what are the 2 main things that it does? What are the 2 main things that you see in this application? Well, as I said, how it's made and what it does. What it is and what it does, right? This is a mousetrap. This is what it looks like. This is how you make it, right? You put the pieces together. That's how you make it. Second, it does this, right? It does this new thing which is to stick mice there so you can get rid of them. Are the two main aspects of your patent application, and they're the two main aspects that you have to disclose to get your monopoly.